Hi, for 2020, the Colorado Division of Real Estate has created a new form. The new form is called Agreement to Revive Contract. Now, we have lived for decades without such a form, so the first question is, why did the Division of Real Estate create this Agreement to Revive Contract? And the reason is that there are certain provisions of the Real Estate Commission approved contract that cause it to terminate by operation of the contract, in spite of the fact that the parties would just as soon keep it negotiating. An example is inspection objection. Might be an inspection objection deadline. The buyer objects before the inspection objection deadline. The inspection resolution deadline is sometime later, say 3 days later. The parties are working on negotiation to try and figure out what the resolution is to the buyer's objection in the interim. And they're getting bids from contractors. They're trying to make guesses about when the weather will get better to do the work, etc. And time passes beyond the resolution deadline. There's still deal momentum. We have a buyer who wants to buy, a seller who wants to sell. The brokers have neglected to extend the resolution deadline, and so the contract terminates automatically after the expiration of the resolution deadline. The parties don't want to go back to the beginning and write up a whole new contract, and so hence the need for this form to revive the old contract. Okay. The next question that people ask me is, John, when is it a good idea to use this new form? When is it a good idea to use this new form versus writing up a whole new contract? And it's easiest for me to address that by identifying certain situations where you should definitely not use the agreement to revive contract. One of the situations where you should not use the agreement to revive the contract are situations where it's been dead long enough, solidly enough, so that the earnest money has already been refunded back to the buyer. Another circumstance where you should not use the agreement to revive contract is where the seller has entered into a backup contract with another buyer, buyer number 2. Now, some people say to me, but John, if it's a backup contract, what is the harm of reviving contract number 1? Well, first of all, this form is specifically not designed to be used in a backup situation. There is a paragraph number 4 that seller represents at the time the document is signed, that's this agreement to revive, that there is no other contract in effect to sell the property. People say, but John, the other contract has a backup contingency in it. Well, different backup contingencies read different ways. Sometimes the backup contingency reads that contract number 2 does not go into first position unless buyer number 1 under contract number 1 acknowledges contract number 1's death. However, not all backup contingencies read that way. The ones in my law firm's clause library read that way, but I would guess that the backup contingencies used by people from my law firm's clause library are less than 15% of transactions, let's say. And more often than not, a backup contingency is going to provide that contract number 2 goes into first position upon the termination of contract number 1, and you would not be using this form unless contract number 1 terminated. So, wisely, the Division of Real Estate has concluded that when there is a backup situation, it is so fraught that the party should not use this form and should be forced to rethink things and go through the trouble of using a whole new contract. That is not saying that using a whole new contract avoids your seller selling the one property to 2 different competing buyers, but perhaps it will slow down the faux pas. Ladies and gentlemen, that is all that is worth saying today about the agreement to revive the contract. Remember our theme, we live in a complicated world. Be careful out there.